ready? Yep. Mobiles up. Yep. Court rise. Appeal in the matter of Chalcot Training Ltd and Ralph and others.
Good morning.
Morning, Mr. Sykes. I can tell you that we have read the judge's judgment, we've read the skeleton arguments, we have looked at the authorities, but I can't say that we've read every word of them. And the way we would like to proceed is to hear both of you on the two company points before we move on to the question of mistake.
Yes. So I represent Chalcot, Mr. Malath and Mr. Rivet represent HMRC, who are the respondents in this action. And we have some additional papers to hand up, both of us do. I mean, nothing very controversial, but if I may start with my papers, which are to be added to tab 5. They're just, it's just a section that's referred to by the judge, which you don't have in your bundles.
Oh, just tab 5 of the authorities?
Yes, first bundle.
Right.
Right.
Thank you.
And that should go at the back of tab 5.
So what have we got? 593 596. Right.
Do the respondents want to hand anything up now?
Well, I wasn't planning to hand mine up now, my lord, but I can easily do so. They're just further provisions.
Well, and if we're going to have all the materials, let's have them all now. Where do these go, Mr. Ballot?
These can probably just go behind tab 5 as well.
Oh, this is part more companies act.
Oh yes, it's section 33, which is
yeah. All right. Well, I'll put 33. I think will go in the front.
Yes, that might be more sensible. Sections 33 and 547. 33 may be fairly familiar. It's just deemed
right. 33 and 547. Right.
Just the covenant between the company and its members. And 547 is a provision about called up share capital.
Yes.
Again, these are for completeness rather than because the case turns in.
Yes. Right.
So, I mean, the starting point is to understand how the scheme works. The contract is at the second core bundle, tab 12. This is the contract that gives effect to the arrangements.
You say tab 12?
Tab 12 in the core bundle 2.
Oh, sorry, I'm looking at the supplementary.
I'm sorry, you only have one core bundle. Apologies.
Yes.
Tab 12.
Yes.
And so your lordships can see that the recitals describe that these arrangements, as part of the employment arrangements between the employer and the employee, and in particular in recognition of the services of the employee during the period ended 31st of March 2012, the employer is willing to assist the employee to subscribe for Class E shares of the employer on the terms more particularly set out below. That's in the recitals. And then C1, in consideration of the employee offering to subscribe for Class E shares, substantially in the form of the offer to subscribe set out in the schedule to this agreement, and subject to the employee complying with the further terms set out below, the employer shall pay to the employee a sum of 10,900, followed by a sum of 1,079,000. This is the first iteration, but the second and third are exactly the same. The numbers change. And then we have the appendix to that agreement, the schedule rather, the form of application for the Class E shares, which is what the employee signs and delivers. And it's noted there, I hereby offer to subscribe on the following terms. In anticipation of your acceptance of this offer, an amount of 10,900 has been transferred to the company bank account. And it's worth noting that when this contract is entered into, there has been a shareholder resolution approving this, the contract and the issue, and also a board meeting approving the contract and the issue. So in effect, it's all been approved, and the acceptance of the offer has been already determined to be accepted by the company. And if your lordships would like, I can take you to those resolutions, but if not, I can just simply note.
Well, I think the judge quotes them.
Yes. So what happens in terms of the cash is that the employee gets, and if I use percentages, just it will make it easier rather than do the whole numbers, gets 100%.
He gets a pound.
He
pays a penny.
He pays a penny straight back.
And keeps the 99p, and the 99p can be called in various events, including at the discretion of the company. But there's a deemed calling if the employee leaves or if the company goes into liquidation.
That's right, my lord. So I can see immediately £1 goes round in a circle, and the 99, if there is a call, will also go round in a circle in due course. Now, the two company law provisions that are relevant to this appeal are Section 580 and Section 552. Now, Section 580 is in the First Authorities Bundle at tab 6. Tab 5, I beg your pardon. And it provides that companies' shares must not be allotted at a discount. If shares are allotted in contravention of this section, the allottee is liable to pay the company an amount equal to the amount of the discount with interest at the appropriate rate. It's worth noting what allotment is, and that's defined in section 558, and that's actually at the back of tab 6. And that provides that for the purposes of the Companies Act, shares in a company are taken to be allotted when a person acquires the unconditional right to be included in the company's register of members. And so this precedes issue. Allotment precedes issue, or can precede issue. And the appellant's case is that Section 580, in working out whether there is discount for Section 580, one takes into account offsetting payments. So where the company pays in order for the subscriber to subscribe and makes that subscriber whole. And that is where there is no element of underwriting going on. The case we're dealing with, it's clear there's no element of underwriting. There's no service being provided in the contract by the employee other than agreeing to subscribe. They're not doing anything else. They're not going out finding other subscribers or doing anything else in the marketplace. This is a very unusual arrangement, and we say that it is necessary to have regard to offsetting payments in applying Section 580 of this kind. Now, it may be different.
Can I just ask you this? No, I have had shares in public companies for quite a long time, and from time to time I'm offered a scrip dividend. I don't pay anything, but instead of getting a dividend, I get some extra shares. Is that caught by 580? Companies paying the money. I'm not.
Well, That has a particular procedure attached to it, essentially a bonus issue, particular company law procedures, and a requirement to have sufficient distributable profits, which are then capitalised. Now, the company's case in this company's case below was that there were insufficient distributable profits. So, and because that point was never pleaded on behalf of the revenue, quite rightly in my submission, because this isn't a bonus issue, this is very different from a bonus issue. There's no findings on the distributable profits of the company which would have permitted that. It's not a point that has been raised before. And of course, this is different to a bonus issue because money's coming out, and that doesn't happen on a bonus issue. What happens on a bonus issue is shares come out fully paid, and that's it.
But the company is, as it were, paid me, instead of paying me the dividend, is given me shares, and I've foregone the dividend. So if one takes into account what you call offsetting payments,
yes.
Why is that not caught by 580?
Well, because this isn't in the form of a dividend. I mean, the whole debate in the High Court was whether this was in effect a dividend or not, and the company said, well, this is a dividend and we don't have the profits. The revenue said, no, this isn't a dividend, you don't need the profits, this is an expense. So it may be on different facts, but in this particular case we don't have distributable profits. There's no inquiry in relation to
I understand that, but your general point is that you must look at each side of the equation.
Yes. Yes, indeed. But there's no declaration of a dividend in this case to be satisfied by a credit to share capital. Similarly, there's no capitalisation of profits in the way that would happen on a bonus issue, which requires particular procedures. Our case is that simple offsetting payments, where there's no service, no element of service being provided, are taken into account for Section 580 purposes. Might be different if there are services being provided. This is a commercial underwriting agreement, but that's not our case. Now, Section 552 is doing something different. That is looking at whether the shares or money derived from the shares, 552 I should say is on tab 6, have been applied in procuring a subscription. I mean, there are many differences between the two provisions, but the key difference is that Section 552 is concerned not with the company getting in nominal value, but with the company not using what it would otherwise be able to receive on its shares, what would otherwise be due on its shares, in order to fund the share subscription. And what that company might be able to get may well be very much more than nominal value. Market value may be significantly more, and that may be the price that would otherwise be payable. Now, the company is no longer pursuing the argument, and I notified HMRC of this yesterday, that the payment that we have in this case is a commission. In my submission, it's a discount for 580 purposes and also for Section 552 purposes. The commission implies, it's hard to, these are points made by HMRC below, to talk of a commission where what you're receiving to subscribe is equal to the entire nominal value of the share. That's a very strange commission, and indeed where no service is being provided in consideration for that commission. And the judge referred to the OED definition of commission in his judgment, paragraph 257. He said it's defined as remuneration for services or work done as an agent in the form of a percentage on the amount involved in the transactions. So it's common ground that this isn't a commission, but my submission is a discount for Section 580 and for 552 purposes. Section 552 refers to company not applying any of its shares or capital money, either directly or indirectly, in payment of any commission, discount, or allowance.
Just so as we're clear, I'm grateful, as I'm sure my colleagues are, for the clarification. But do you say that there are circumstances in which something can not be a discount for Section 580 purposes, but can be a discount for Section 552 purposes?
Well, so Section 552 is looking at a discount to what would otherwise be payable on the share. So it may be that a share with a nominal value of 100 has, in the prospectus, been sold to prospective investors at 200. So 200 because that's the market value. So 200 is what the nominal purchase price is. It's what could otherwise be obtained. However, there's a side deal whereby some of the 200, let's say 100 of the 200, is going to be paid back to the subscriber. Now that wouldn't breach 580 because the nominal purchase price has been obtained. It would breach 552.
Well, to be sure, but maybe my question wasn't clear. Of course, the two sections have different purposes.
Yes.
And will apply in different circumstances. I was trying to focus on the word discount and whether it had a different meaning on your submission in the two sections.
Well, I'm not sure how to answer that, my lord. I think not. If one is not getting in the full amount of money because there's been a payment back, in my submission, that's a discount. It doesn't matter that it takes the form of a payment back rather than a reduction in the amount prima facie payable. And indeed, the section refers to payment of any commission or discount, payment of a discount.
So discount from market value, is that how you're interpreting 552?
Well,
580, I think, is discount from nominal value.
well, yes, indeed. I just one qualification to that. It's as the case of Hilda and Dexter confirms, it's not exactly market value. It's the rebate on what would justly be due from the shares. So it may be that there's no obligation to issue shares at market value, but if one does issue shares at above nominal value, generally speaking, prevents a side deal whereby some of that additional money is returned.
Right. So what you are discounting from is different in the two sections, you
yes,
say?
Yes. And I also say that discount in both sections does take into account a compensating payment, if you like.
Can I just ask you another question before we delve into it further? Section 580, subsection 2, tells you what the consequences are of contravening the section. Is there an equivalent for section 552?
I believe there is, my lord, but I don't have the section to hand. Because otherwise there's no apparent sanction. So I believe I'll check that in the break. Now, that's by way of an overview. I mean, I don't actually intend to speak for very long. I had sort of in mind about an hour and a half.
All right.
But that was including mistakes, so I'll try and be brief. Because actually there's only really a few points that need to be made on this. Now, what I need to focus on, I'd like to focus on first is section 580. And I noted that section 580 is looking at the time of allotment. It's not looking a decision has to be made at the time of allotment whether Section 580 is breached or not. When one isn't necessarily looking at the payment flows that happen at any particular point, one is looking at what are the terms of this deal. Is nominal value going to be got in? And that reflects it's a reflection of the fact that a share, subscribing for a share, is an agreement to become liable, and that is set out by Lord Halsbury in Regum, which is at tab 14 of the first authorities bundle at page 168.
168
is the second paragraph beginning, I think. And I'll give your lordships a moment just to read that paragraph.
I think with Lord Justice Fry, that.
Yes.
Yes.
So the question of whether there is discount is to be assessed at the time of allotment, and the nature of a share is an agreement to become liable to pay the company for which the amount for which the share has been created. Now,
so there's no need to pay up front.
There's no need to
you
pay.
You could agree to pay at some point in the future.
Indeed. And what the assessment is, when you have paid, will you have paid nominal value? That's the assessment. That's the first point. And the second point is that in performing that analysis, one is looking at the contractual consideration for the issue of the share. And it will be sufficient if I take your lordships quickly to two textbooks confirming this point, which are at the third authorities bundle, starting at tab 48, Paul Brown and Companies.
48, did you say?
Yes, my lord. And it's the third paragraph, sidelined. The company cannot by a contract make that which is not a good consideration in law a valid payment shares. And in addition, Palmer's Company Law, tab 45. Page 919 of the bundle. Thus, if a valid contract is made by the company for the allotment of shares in consideration of specific property or of service of substantial value, the court will not examine whether the consideration is adequate so long as the contract stands. However, there must be some consideration, and so shares issued for a past consideration or by way of a gift cannot be treated as paid up, and the allottees can be made liable to pay for these. And all of this, the fact that one is looking at the fresh consideration which the company receives for these shares, reflects the nature of a share subscription in accordance with Lord Halsbury's speech in Oregon, which is that it's an agreement to become liable. You can't become liable. You've got to be becoming liable to give some fresh consideration.
So you say that's just a question of ordinary contract law?
Yes, yes, my lord, absolutely. Now, second point is that discount, assessing whether discount, and this is where the judge disagreed.
But wait a minute, isn't there a bit of a disconnect here? In Edistone, for instance, the shares were allotted as fully paid, although the directors or whoever, the allottees, in fact paid nothing, because it was argued they were being recompensed for past services. Here, Miss Stoneman and Mr. Ralph will have to pay something if and when called. And why is that not the consideration for the shares? I know you say you should take into account what the company pays them.
Yes.
But just looking at it as a question of consideration, they will pay
Yes.
the
Yes.
100p
Indeed.
on the terms of the subscription agreement.
Indeed, one can take the services out of the equation in my submission. The real issue here is, does one take into account the payment made by the company to Miss Stoneman and Mr. Ralph for the offer to subscribe? That's the real issue.
Yeah.
Does one take that into account for 580 purposes? And there are three authorities which bear on this point. And I'll deal with them in terms of, in order of seniority. First, chronologically, is Metropolitan Coal, which is tab 16 of the authorities bundle. And this is a Court of Appeal case in which it was held that ordinary brokerage didn't lead to a discount, and it's the speech of Lord Linley, page 199 of the authorities numbering, which I'd like to take your lordships to. So here there's been a payment to brokers. Now, and the judge says, now how can what this company has done be said to be issuing shares at a discount? The transaction here is this: the company have authorised their directors to pay brokers a fair and reasonable commission for their services in procuring people to take shares. What is there contrary to the Act of Parliament in that? What is there illegal in that in any sense or shape? I confess I cannot see the slightest sign of any such thing. That it may be so manipulated as to lead to the issue of shares at a discount is possible, and when such a case arises, we will deal with it. But there's nothing of the sort here. So this makes it clear that where there's ordinary commission, we don't get into this discussion. But when we have an artificial payment such as the one in issue in this case, we do. And an example of that is the second case that I'd like to take your lordships to, which is Hong Kong and China Gas, which is at tab 22.
So just pausing there, I think we can see from page 201 in Metropolitan Coal what Lord Justice Lindley was talking about, having referred to another case. He says the whole thing was a juggle from beginning to end, and we disallowed it on the ground that it was an improper transaction, and so it was. So that's what he's talking about by manipulating. So you say this was a juggle, do you?
I say there was no service here in the slightest. This is not an ordinary brokerage. This is simply a payment made to subscribe the shares. Nothing further is being provided. The money goes around in a circle. The 1% goes around in a circle, and over time, the 99% will also go around in a circle. It's not the kind of brokerage that's being talked about in Metropolitan Coal. And then we come to Hong Kong and China Gas Company, which is at tab 22, not cited for the judge. And also a case that was decided on the law after the Companies Act 1900 had been introduced. It's the Companies Act 1900 that brings in the forerunner of Section 552. And that was already on the books. If we look at page 306, beginning in the middle of the second paragraph, this was an agreement where certain subscribers would be permitted to subscribe, but they would receive the money to subscribe the same time. So it's the wording beginning for while the first part of the article contains an obligation to allot to Thomas Glenn or his nominees 1/5 of all increased share capital. The second part of the article provides that contemporaneously with such allotment, the company shall furnish cash equal to the full nominal value of the shares and earmarks and dedicates that cash so that it has immediately to return to the company's coffers for the purpose of paying up the very shares in full. It's impossible, in my view, to hold that the second part of Article 8 does not amount to a contract for the contemporaneous absolution and discharge of the allottee from his prima facie statutory liability to provide the nominal value of his shares in money. In my submission, that is exactly what we have with the 1%. It's exactly the same. The 1% goes out and it comes back in, goes out from the company and it comes back in. Absolutely no difference between the facts on this case where it was held that amounted to discount. Now, as regards the 99%, the timing in my submission doesn't make any difference. The fact that the 99% stays out of the company for a little while longer before coming back in doesn't alter the fact that when you look at the time of allotment and you ask, what is the company getting overall from this bargain? Is it getting its nominal value? The fact that there's a delay doesn't alter the answer to that question. One looks at it overall, not making a distinction between cash and the promise to pay cash, and one is driven to the answer that the company is getting nothing at all. And if timing is relevant, it's relevant, how long does the gap need to be? 1 day, 2 days, 1 week? How would you assess this at the time of allotment when the company may not even have made a call, but maybe about to make a call the next day? Timing can't be relevant to this. One is looking at whether it's the cash or the promise to pay cash. There's no distinction. And if the subscriber has received equivalent value, then the subscriber isn't putting a net amount of nil into the company. And that's exactly the same as here. So there's no distinction in my submission between the 1% and the 99%. The 1% is clearly the same as in this case. And thirdly,
so I think I understand that point, but do I understand that it follows on your argument that one must disregard the reasons why the 1% and the 99% are being paid?
yes.
Which on the judge's findings was because they were remuneration for the employees.
Yes, but what's the contractual consideration so those payments are being, what we're concerned with is the contractual position, and the contractual position is as set out in the subscription agreement. These amounts are being paid in consideration of the employee offering to subscribe for the Class E shares of the offer to subscribe. That's why they're being paid. So there isn't a right, a contractual right to remuneration, which is then discharged by these arrangements. There isn't any such right. I'll come on to the services point later, but essentially what the judge decided was that these payments were made pursuant to a valid power to pay remuneration. And that power, it's clear from the cases, in particular Holt, which was the case relied on by the judge, applies equally to gratuities, to payments which aren't contractually due from the company, but it's got a power to make payments to directors in recognition of their services. And it does so. But because the company isn't under any obligation to pay, it isn't being relieved by these arrangements of any obligation. It isn't getting any fresh consideration from the subscribers.
Is that right? The articles say directors are entitled, it uses the word entitled, to such remuneration as the directors declare. The directors take up office on the terms of the articles and perform their directorial duties on the terms of the articles. Are they not at least entitled to have the board exercise its discretion rationally and in good faith, with the consequence that once the discretion has been exercised rationally and in good faith, and an amount declared, the directors are entitled to that amount. It may be retrospectively determined that they are performing their duties in the expectation that the discretion will be exercised, in the same way that an employee whose contract entitles him to a discretionary end-of-year bonus is performing his duties as employee on the basis that the discretion will be exercised. But it doesn't turn that into past consideration. It is part of the package on which he is performing his services.
So, as found by the judge, the employment agreements did not contain a bonus, whereas they did for the employees, a bonus mechanism. Secondly, the articles are a contract between the members qua members, and they provide the virees for the board then to award a bonus, but they don't actually provide a right to the employee. It's simply an agreement as between the members. Now, there was a case cited to the judge below on that point, because it's not a point raised by the revenue. I haven't got it to hand, but I can find the name of the case. And thirdly, there's no suggestion that that actually was the fact of the case, that they were working with a view to receiving this particular bonus payment. So that, in my submission, is the answer to that. And in fact, one of your lordship mentioned the Edis case. There's also another case which is relevant to that point, which is Park Business Interiors, which is at tab 28 in the second authorities bundle, which is a Scottish case. And it's page 433. It's about pre-incorporation services and payment for them. And in Scotland, consideration, there's no rule against past consideration, as your lordships will know. The judge refers to the English law and distinguishes it. He says, however, this is B, however, insofar as the authorities suggest that a past consideration, such as services previously rendered, will not entitle a company to make such an agreement, they appear to be based on the general requirement of consideration in the English law of contract. Hence, it suggested in Pennington's company law that the company execute a deed under seal where the consideration is a past one. There does not seem to be any authority to the effect that the Scottish company cannot simply contract in Scotland to remunerate or reimburse a person who has rendered services in setting up the company. So what one would need to have done is to declare a bonus, enter into a deed to make that a valid debt, and then offset the payment for the shares against that obligation by the company. That would have been good consideration. And the fact that one could have done it, your lordships will see that in the cases, there are, particularly the cases dealing with commission and discount, it's always possible to do things another way that doesn't offend commission or discount, or rather, it often is. And the cases, I'll take you to a couple of authorities, say repeatedly, well, it doesn't matter what you could have done, we need to look at what you actually did do. So an example of that is Reagan, which is in the first authorities bundle, tab 14. page 172. And this is where, this is where shares were issued to subscribers.
You say
172.
Yeah.
Shares were issued to subscribers as paid up as to 15 out of the 20 shillings. So the subscribers only paid the 5 shillings. It's held that this was discount. And the paragraph, the second paragraph on page 172 deals with the point that they could have done things differently. They could have issued shares with a lower nominal value. And Lord Watson says, it's needless, at the end of that paragraph, it's needless, however, to consider what the parties might have done if that which they did is not of legal effect. Similarly, in Welton and Safri, which is at tab 17 on page 236, and it's the first paragraph, at the end of the first paragraph.
Sorry, page?
Page 236, my lord.
236.
And what is being rejected there is the idea that you can, in effect, rework the deal and apply the law to that. They could have done these arrangements in a way which avoided discount. However, whether they would have had the intended tax effect is a different question. And I submit, or it appears clear, that this was done in this way for the intended tax effect. But with that comes the risk that the arrangements don't work. So I was going through the three authorities on the offsetting payments point, and I've taken your lordships to the Hong Kong case. The final case is the Australian Investment Trust case, which is in the second authorities bundle at tab 25. And this is distinguishing a contract where services are provided, underwriting services are provided, and a contract where all the subscriber's doing in return for receiving money is agreeing to subscribe. And so the first paragraph there, beginning now.
Sorry, which page?
I'm sorry, my lord, page 379.
Thank you.
Lord Watson,
Lord Tomlin.
Lord Tomlin, I beg your lordship. So Lord Tomlin says, now it's not disputed that an agreement by a company to pay a commission to a person in consideration of his subscribing in presenti for a definite number of shares in the company's capital would be ultra vires the company. It would in effect be an arrangement whereby he was allowed a rebate or discount on the amount payable by him for the shares for which he agreed to subscribe. And then the third paragraph down, for the purposes of determining whether such an underwriting agreement is within the powers of the company, their lordships are content to apply the test suggested by Lord Watson in the passage already quoted from his speech in Oregon. What are the services rendered by the underwriter in return for the commission over and above his agreement to subscribe for shares? In their lordships' opinion, the answer must be that there are none. Now, if that's the case, then one can take that payment into account as offsetting the nominal purchase price, because nothing additional is being provided. And that reflects the Hong Kong case, which preceded this case. Now, The judge...
Can you just explain
Yes.
why it wasn't disputed that paying a commission couldn't be done in the light of the Metropolitan Coal case?
Yes.
Why is that? Why was it common ground?
But it depends, well, because this is a commission in inverted commas where all that is happening is that someone is being paid to agree to subscribe.
Oh, I see.
Now, those commissions where something more than that is being done, those are dealt with in section 552, but a commission in inverted commas or a payment simply for subscribing is also within section 580. And that's what Lord Tomlin is saying. And that answers essentially the judge's point on this. You can't just relegate everything to section 552. If you have got a payment for nothing more than the obligation to subscribe, then that is also relevant to discount. And 552, it's worth noting, was not introduced in order to find clever ways to avoid discount. It was introduced to facilitate underwriting. If one looks at Hilda and Dexter, which is really the case which says the most about section 552, one can see that. And that's in the first authorities bundle at tab 19. Page 257, where Lord Davy Davy says in the first the paragraph beginning from a perusal of the 8th section of the Act of 1900. This is the forerunner to section 552. Your lordships will infer that the legislature was desirous of enabling remuneration to be paid for services rendered in placing or procuring subscription of the company's capital, and it appears to have hit upon what may be termed a compromise, and then that sets out section 552. So the distinction is between a pure payment to subscribe, which is the kind of payment in the Hong Kong case, referred to also by Lord Tomlin in the Australian, which was the subject of the Australian Investment Trust case, and a payment where, although there is a subscription by the person receiving the payment, services are also being provided. Simply an offset, nothing more is being provided, then 580 is engaged. And it's interesting to note that the modern, the similar kind of distinction can be found in the Company Law Directive, which I think HMRC are going to take your lordships to in due course, which is in the first authorities bundle at tab 4. Under Article 8, shares may not be issued, it's page 13 of tab 4. Under Article 8, shares may not be issued at a price lower than their nominal value, or where there is no nominal value their accountable par. However, member states may allow those who undertake to place shares in the exercise of their profession to pay less than the total price of the shares for which they subscribe in the course of this transaction. So the distinction made by Lord Tomlin finds an echo many decades later in the second Company Law Directive. Now, the judge said that the cases cited to him on offsetting payments were before the rules on discount had been enacted and that the law, it couldn't be assumed that the law was the same. However, in my submission, all that the enactment of the rules on discount do is to give effect to the common law. And indeed, the first enactment of the rule on discount was section 37, of the Companies Act 1928, which is at tab 1 of the authorities bundle. And what that does is actually, it doesn't contain the prohibition, it's still working off the common law prohibition on issuing shares at discount. It's permissive, and it permits shares to be issued at a discount in certain circumstances. So clearly it is engaging the common law prohibition and is parasitic on it. It's not attempting to change the law.
So section 16 prohibits the giving of any financial assistance for the purpose or in connection with a purchase.
Yes.
If that's codifying the common law, as you suggest.
Well, I was suggesting that section 37 was codifying the common law. That's on page 6.
Oh, I see.
Yes, it's the rules on discount. So, as it happens, there were provisions on financial assistance introduced at the same time. But the point is that section 37 is the first time the Companies Act refers to discount, and what it's doing is it's permitting discount, notwithstanding the common law prohibition. So it's confirming, if anything, the common law prohibition. But the point on financial assistance, I'll deal with it now, is this is dealing with something completely different. For a start, financial assistance applies to existing shares as well as shares to be issued. It's much broader than section 580. Secondly, and it prohibits a company assisting any purchase of shares, whether new or existing. Secondly, it doesn't do anything other than make that criminal offence. You still need section 580 to ensure that the shares are issued, that the discount is repayable to the company. That's the effect of section 580 sub 2. You need, in a case where there is discount, 580 sub 2 to make that discount in effect go away. And thirdly, there's no reason why the two provisions can't work at the same time, hand in hand. So if one issues shares at a discount, financial assistance rules are engaged, they make that a criminal offence, but they don't cause the discount to be repayable to the company. That's section 580 that does that. So that has nothing to bear on this issue, although it's a point relied on by HMRC and by the judge. The parliamentary debates with respect to the introduction of section 37 Companies Act are relevant because they explain or give the Lord Chancellor's view on the reason behind the prohibition on discount. And I mention that in the context of the judge's argument that you can't apply the law as set out in the pre-1928 cases to the situation post-1928. It's useful to look at the debates that were had in Parliament.
So on what basis do you say that the criteria laid down in the post-Pepper and Hart case law are satisfied?
Well, I'm not actually wishing to cite that to elucidate a particular term. It's just part of the general background to the 1928 Act, part of the general sort of statutory background. It's not an interpretation tool as such, and that is Authorities 3, tab 42. Page 896.
Yes.
And so the passage that's sidelined, I'll let your lordships have a moment to read that. I think this just makes clear that Section 37 is codifying the common law. Well, creating an exception to the common law prohibition. And then in the second column at the bottom on page 896, your lordships can see the Lord Chancellor's view as to the reason behind the prohibition on discount. So Lord Chancellor says you have a company with an authorised and issued capital, let's say of 1 million, and the unwary person who is asked to deal with the company thinks that a company with a capital of that amount may be regarded as solvent for ordinary debts. If these words be omitted, the company could issue its 1 million capital for £1 or even 10 shillings, and therefore the public would have no sort of protection at all. Similarly, if these words be omitted, the minority of the shareholders might easily find themselves placed in a position in which shares with preferential rights were issued at enormous discount, and therefore the value of their own shares, which rank behind the preference shares, would be absolutely destroyed. So discount isn't just about protecting creditors, it's also about protecting other shareholders. And one needs to respect the rules because they're there for these reasons. So in conclusion then, my lords, on the point about offsetting payments, we've got 3 cases which indicate that offsetting payments where the consideration for the offsetting payment made by the company is simply an agreement to subscribe. 3 cases in which those that have been dealt with by the courts and said to cause discount to arise if they call the net amount to fall below the nominal value.
Forgive me.
Yeah.
There's only one case, isn't there, with offsetting payments, and that's the Hong Kong
Yes, there's
case.
the Hong Kong case.
The others are all payments foregone. They're not payments made and offset.
Oh, well...
are they? In Eddystone, nothing was paid. In the Australian case, as I understand it, the full price wasn't paid, but it was said to be commission. I think it's only the...
well, the Australian...
I may have misremembered the facts, but
Yes.
I think it's only the Hong Kong case where there was a flow of money in both directions.
So in the Australian Investment Trust case,
Right.
your lordship's talking about what actually happened in the case. So here there was a payment.
Sorry, just remind me which tab?
So this is tab 25, page 379.
20.
Where there was an underwriting commission paid granted this is a Privy Council case, but there was a commission paid for agreeing to subscribe for shares.
So where's the payment?
We're looking at the head note. So the appeal in substance was as to the validity of a written agreement by which the appellant company underwrote the whole of an issue of 175,000 ordinary shares for a commission of 1 shilling upon each share underwritten.
Sorry, where
I'm just looking at page 368, 369, just the head note.
yeah. But I think that was an allowance. I don't think there was actually a payment, was there? Well, anyway.
Yes. Well, I think it's dealing with a payment, but your lordship is right that the Metropolitan Coal case is not. The offset, there was a payment there as well, and what's being contemplated is simply that there can be a situation where an offsetting payment amounts to discount, but those 2 later cases suggest that that's the case, and indeed that makes sense. I would submit that one can't simply fall out of section 580 by circular payments. That's Chalcot's case in essence. Now, I've dealt with financial assistance, the accounting. So the accounting obviously doesn't make any difference to the question of the contractual consideration received by the company. It's worth noting why the accounting worked in the way it did. So we don't think this accounting is correct, incidentally, but this is the thinking behind the accounting. Is that there's a payment that hits the profit and loss account, which is the 100 that goes out, and then the 1 and the 99 don't go into the profit and loss account as income because they go into share capital below the profit and loss account, and therefore the payment back, if you like, is never going to cancel out the expense on the payment out. So the payment out is an expense. It's called an employment expense in the accounting. But the 100 that comes back, the 1 and the 99, goes into share capital, not the profit and loss account, and therefore an expense results. So I make this point because to highlight that the people who came up with this scheme needed this to be in this particular form in order for that accounting treatment, which fed into the tax treatment, to apply. So that's why it was done in the way that it was done. And in my submission, that gives rise to discount. Now, I'll deal briefly with section 552.
Just before you move on to
Yes.
552, I've got one
Yes.
last question on
Yes.
580. Section 580, subsection 2, tells us that if you contravene section 580 subsection 1, let's find it. The allotee is liable to pay the company an amount equal to the amount of the discount with interest at the appropriate rate. If Mr. Ralph were to pay either the 99p or the 100 to the company under section 580 subsection 2, would that discharge his obligation when called upon to pay the 99 to pay the 99?
No.
And if it would, what is the mechanism by which it discharges that obligation?
Well, the answer to that, my lord, I'll deal with Mr. Ralph in a second. If one can pose the question in relation to Miss Stoneman, who entered into all 3 iterations, I'll deal with Mr. Ralph in a moment, because the claim against Mr. Ralph has been compromised for £300,000 because he had no money. Miss Stoneman repaid the amount into the company under section 580. However, she is still liable on a call. There is no mechanism to relieve her of that, and the judge erred in finding that. The judge talks in the context of mistake about an alternative remedy to avoiding the transaction under principle of common mistake, but there is no alternative. She is liable.
So the company gets money twice?
Yes, yes.
Sorry, that sounds like double recovery. How
Yes.
does that work?
Well, the reason that that's double recovery is that the shares are not worth very much. Although their nominal value is 1, their actual market value is considerably lower. So if the shares were worth something, that might make sense that she pays the discount. She pays the discount back. She's got to pay on a call. That might make sense, but in this situation, it doesn't.
Thank you.
Well, yes. Okay. So
552.
552. So tab 6 deals with section 552, and I'll be brief on section 552. So it's common ground, incidentally, that 553, even if this had been a commission, these payments had been a commission, 553, the conditions for 553 wouldn't have been met. Just mention that by way of background. But we're not contending it's a commission. We're saying it's simply discount. A company must not apply any of its shares or capital money, either directly or indirectly, in payment of any commission, discount, or allowance to any person in consideration of his subscribing or agreeing to subscribe for shares in the company. Now, what this is looking at is not nominal value, but the amount that would otherwise be due. So if I could take your lordships to Hilda and Dexter, which is at tab 19, which is still in the first authorities bundle, page 258. So it's page 258, and the paragraph beginning, the first words to be construed are apply any of its shares or capital money. And what the judge says, Lord Davy, I think that these words naturally mean by its capital, either in the form of shares before issue, when they may be described as potential capital, or in the form of money derived from the issue of its shares. And then the word discount or allowance seems to mean the same thing, namely a rebate on what would justly be due from the subscriber of his shares. It's not about nominal value, it's about a rebate on what would justly be due from the subscriber on his share, which may be more than nominal value. So when the section talks about shares and capital money, and the judge says that that means potential capital or money derived from the issue of its shares. What that's suggesting is it's looking at the money, it's not looking at sort of capital money in an accounting sense. It's saying the money that you would get from the shares in a loose commercial sense. So are you applying shares or capital money? In other words, the money from the shares in procuring subscribers. So it doesn't, the section...
So you say it's not the nominal share capital, it's the proceeds of the issue.
Yes, or that would otherwise have been received from the issue. Let's say that one is issuing shares to the public and one makes a side arrangement with a particular person, then that would apply, or a return of the monies from the subscriber in question. But it's looking at the application of shares or capital money. It's saying the amount that shares described as potential capital, it's saying the money that you're getting from this issue, are you using that?
And what are you comparing it with? What you could have got?
Well, what would justly be due from the subscriber on his shares? So that is...
Well, I mean, if a share is trading on the stock exchange at £5, and the company wants to raise some capital and it decides to issue a rights issue
yes.
at £4,
yes.
that wouldn't be caught, would it?
No, that wouldn't be caught. And indeed, there is a case that's in the authorities bundle that says there's no obligation to issue at market value. But let's say you are issuing at market value. That's the terms of a particular offer, but you reduce the price for one particular person, or you repay an amount, notwithstanding an agreement that's been entered into which entitles the company to a higher amount. Well, then these provisions would be engaged. But it's looking at protecting. It's looking at the application of the money you would get from the shares. It's not concerned with balance sheet accounting. So let's say that you receive subscription funds from a subscriber and then you pay that subscriber the amount back. That would be an application of capital money. So I receive 100 on a share. So either company receive 100 for my shares, but I pay 100 back to the subscriber. That's an application of the capital money. And let's say I do that because that person agreed to subscribe for the shares. That falls squarely within this section. It doesn't matter that 100 that I pay out may have been debited to reserves. My submission, that's an irrelevant consideration. This is looking at things in a much more commercial substance type way. Has the money that I have received been applied to procure, or that I would have received, or that I did receive, been applied to procure subscriptions? And I make that point because the revenue rely on reserves being debited, but this is not an accounting test. This is saying, have you got the money that you're entitled to, or have you paid it out? And it applies if that's direct or indirect. Section 552 uses the word directly or indirectly. Now, if I receive an amount on a subscription, either company receive an amount on a subscription and then I pay it out, in my submission, that's squarely within section 552. But if we reverse the order, so I pay the money out in order to procure that someone then pays it into me as a subscription, in my submission as subscription monies, in my submission, that is an indirect application of capital money. Particularly where there is, in the case where there is a causal link between the payment that I make to the subscriber and the payment back on the share subscription, because one is consideration for the other. So the indirectly language means that one is approaching the arrangements in a substance over form way rather than looking at sort of particular timing. Now, on this case, the simple fact is that the money that was received, the one, has been paid out at the same time as it came in, and the 99 is also going to be has also been paid out. So that the promise, the potential capital, the promise of the 99 has in effect been paid out by means of the 99 of the 100 payment that's made by the company to the subscriber. So my submission, section 552, is in point equally. So that both provisions apply in this case. So those are my submissions, unless your lordships have any questions on the company law aspect.
Just 2 points. What were the judge's findings about where the money came from? It came from reserves, was it? Was it trading income?
Yes, it was trading income because there was a well, we don't know whether it came from reserves or not. In fact, the company's case was that the reserves weren't sufficient for the payment. Some of the money came, well, it can only have come from the business, the money, the actual cash.
Yeah, so it was trading income.
It was trading income. I think there was a big contract with DHL.
And I suppose it would have had to have been in order for it to... Oh, no.
Well, no, because on the revenues case, you don't need reserves. It's an expense.
Yeah. Right. But anyway, that's what the judge found. It was made out of trading income. Right. Okay.
Well, that was the evidence.
Yeah.
I don't recall.
The second point is not really a question. It's just to remind you, you're going to show us at some point the section which tells you what the consequences are of a contravention of section 552.
Yes, thank you, my lord.
Yes, Mr. Vallet.
Good morning. I hadn't expected to be on this quickly, and it may be that my proposed approach is too slow for your lordships in light of what my learned friend has said.
If it is, we will tell you.
Well, I wasn't in doubt about that. From HMRC's point of view, the appeal is very simple. As your lordships are aware, the appellant company carried out 3 iterations of a tax avoidance scheme that was intended to procure a tax deduction for the payment of directors' remuneration and to make funds available to the directors, but without triggering the income tax charge that would result from a straightforward payment of remuneration. It did this by paying the directors or crediting amounts to the directors' loan accounts, but at the same time requiring that the directors subscribe for further shares with a nominal value equal to the amounts credited to the loan accounts. The shares were paid up as to 1%, with the remaining 99% uncalled. Effectively, this gave the directors an interest-free loan. I set that out because my learned friend's starting point, I would say, was the wrong one. My learned friend started with the share subscription or allotment agreement and ignored the rather important context of the primary findings of the judge that the payments and the credits to the directors' loan accounts were remuneration. The remuneration wasn't some sort of agreement to enter into a share allotment agreement. The remuneration was the payment. And this this is the revenue's answer to your lordship's question about whether one can ignore that in approaching 580. The revenue's answer is that one can't. Now, there's no doubt at all that that was the purpose of the scheme. That's the judgment at paragraph 170 in the core bundle, tab 7, page 133. I can turn these revenues up, or I can just leave them for your lordship's notes as is convenient. But there's no doubt about the purpose of the arrangement.
170 and 173, did you say?
170 at page 133 of the core
page
bundle.
133. Thank you.
That's the bundle reference, not the internal reference.
Yeah.
The company wasn't purporting, frankly, to raise share capital, not overall. Now, before the High Court, the main argument, of course, was whether the payments and credit to the loan accounts were remuneration, as had appeared in the original account and as the revenue argued for, or a distribution. If it had been a distribution, the appellant company argued that it was unlawful and that various transactions should be set aside. And the parties were eventually agreed that it was a straight choice between remuneration and distribution. The payments and credits were one or the other, without some hybrid middle ground. Again, I'm labouring this point because there are times in my learned friend's argument and in his skeleton when he appears to suggest that the remuneration was something other than the payments and credits. Now, all of that, that evolution of the argument is 167 to 168 in the judgment. It's the previous page, page 132 at tab 7 of the core bundle. Now, of course, what the learned judge held was that the payments made to the directors were remuneration. That was the conclusion on the main issue, the first issue. That's 220 to 224 in the bundle. And that is a conclusion based on substance, not labels. One sees that very clearly earlier in the judgment, 176 to 177.
Well, I think that's why Mr. Sykes is arguing his past consideration point, isn't it?
Well, no doubt. I mean, my learned friend's approach clearly is to focus on that allotment agreement as if it existed in a vacuum. Because if it existed in a vacuum, the only thing that the payment could be for is the issue of the shares. And that's how he gets his Section 580 argument going. I mean, as I understand it, there's no real difference actually between the 580 and the 552 argument. Each argument is saying, well, the company didn't get all that it should if we're talking about par value, or could if we're talking about nominal issue price from the share subscriber. They got in less than they could or should have done. That's the essence of either argument.
Well, he placed some emphasis on the circularity of the money flows.
Of course. And as to 1%, there is a circularity of the money flow. But there's no objection to the company, paying remuneration on condition that it's applied in a certain way. And there's no broader objection to a company issuing shares paid up in whole or in part, provided it's doing so properly, provided it's not issuing at a discount or issuing at a commission under 552. So one has to look at that wider context. And those findings, that finding that the payments and the credits were remuneration, has not been appealed. And to repeat, the appellant cannot now say that the only remuneration was something less than the payments and the credits. Now, there's a separate question, which we may have to talk about in the tax tribunals, how one quantifies the remuneration for tax purposes, but that's not for this court, and it wasn't for the High Court previously. Now, all of that is set out in our skeleton at paragraph 1 onwards. Facts, I don't think I need to rehearse beyond that. They're set out briefly in our skeleton at paragraphs 5 to 9. And there's a rehearsal of the issues following that at 10 to 13. I had been proposing to say quite a lot about 580 and what it means, but I think we are actually agreed, Ellen Friend and I, that what 580 is aimed at is the situation where the company gets in less than the par value of the shares, including not just immediate payment, but the reserved right to make further calls on the share. It's not quite the same as discount in 552, where the same word discount is used to mean something more like commission. But I can come back to that. We're also agreed, if it matters, about what the allotment is, the allotment of shares, the point at which the subscriber or the putative member becomes unconditionally entitled to be registered. That's the allotment, as opposed to the issue, which is when the member is registered. That should be uncontroversial. We don't think anything, we, the revenue, don't think anything turns on that distinction, and it now appears to be common ground. So what all this means is that a company limited by shares cannot limit the liability of the shareholder to less than the par value of the shares. I'm putting it that way round because of the historic origins of the rule. Before 1862, I'm sure your lordships have a far better grasp actually of company law development than I do. But before 1862, members of a company limited by shares had unlimited liability because companies were essentially and originally a form of partnership. The innovation of the 1862 Act, or this innovation, was to allow the formation of companies limited by shares with limited liability, so that the liability of the shareholder was limited to amounts unpaid in respect to those shares. And Lord Morris explains that in Oregon at page 148. Again, I don't think we need to turn that particular passage up. It should be uncontroversial. So a company cannot issue a £1 share as fully paid up, but only get in 50p, 10 shillings, and waive its right in some way to the remaining 50p. That would be a breach. Now that isn't to say, of course, it isn't to say that the company must call for the full par value immediately. And it may be helpful to look at 547, which was the additional section that we handed up, one of the additional sections that we handed up that I think went in tab 5 of the local authorities document. So I may be labouring this point when it's common ground, but what one can see, 547, what is shared up called up share capital, it obviously equals the amounts called on the shares. That's easy, together with any share capital paid up without being called, and any share capital to be paid on a specified future date under the articles.
Well, this whole idea is in the very definition in section 3 of what a company limited by shares is. It's the member's liability is limited to the amount, if any, remaining unpaid.
Oh yes, remaining unpaid. The additional point that one might want 547 for is first that the share capital can be paid without being called. So the shareholder doesn't need to wait for the call, but can pay it up in advance if they want to do so for any event. And also that the called up share capital includes amounts which have been called for payment in the future. So I mean, it's not something that I understand happens frequently these days because companies tend to issue shares for tiny par values. But if companies had issued shares for meaningful par values, they might stagger the calls either under the terms of the articles or under the terms of the allotment. And those future amounts would count as called up share capital. So what one has overall in relation to the share capital, the simplest case perhaps is where the share capital has been called and paid, and then it just sits in the share capital account, as one would expect. It might have been paid without being called, and again, that will be in the share capital account. It might have been called but not paid, and that changes things slightly. At that point, the shareholder owes a debt to the company. So if someone hasn't yet honoured the call, they're a simple debtor, and one can see that under section 33, which is the other provision, if we need to turn that up. Or the share capital can be uncalled, in which case the shareholder is not a present debtor, doesn't have a present immediate debt to the company, but obviously has a contingent liability that might depend on events specified by the articles or might be at large. So those are the 4 options for the share capital. And what 580 prohibits is a 5th category where the shareholder hasn't paid the full amount, the full par value, but the company has in some way restricted its right to call for it either immediately or on a liquidation. So in my submission, 580 is quite a technical provision intended to ensure that a creditor or another shareholder inspecting the company documents can determine the share capital. And then the friend turned up the relevant passage of Oregum, making that point. The idea is that if the company has issued £1 shares, the putative creditor should be able to see that the company has received or is entitled to receive £1 per share. If the company is purported to limit its right to receive less than £1, then of course the putative creditor won't get a true impression of the company's available assets, from the accounts. This isn't a perfect mechanism because, of course, the share capital is to be set against the company's liabilities, and simply looking at the share capital account won't reveal in itself whether the company has trading liabilities that have arisen naturally. But it is intended to be an indication of the company's fundamental resources. And 580, because it's in that sense a technical provision, we would say isn't and cannot be construed as some sort of ancillary bar on financial assistance. And that's a different regime, still in place for public companies but not private companies. That appears to be what the appellant's approach would result in. If one has to look at whether any payments by the issuing company reduce or should be taken to reduce the net receipts on the share issue, that would be the effect of Section 580. It stops being a technical provision of relatively easy application and becomes a difficult provision to assess. Has the company got value for any payments that it's made out? I appreciate that issue may have to be carried out in relation to 552, but the valuation issues in 552 will necessarily be more difficult because they're concerned not with the par value of the shares, but with the amounts that might justly be asked for them. The point I've just made about financial assistance is one that was made in the judgments as well at 240, core bundle, tab 7, page 148. And again, 580 has nothing to do with share premium, the amount above and beyond the par value of the share. That's also common ground. That's paragraph 17a of my learned friend Skeleton. And what that means, of course, is that a company issuing £1 shares for £1 paid up would not be in breach of 580 merely because the market value of the share was over £1, or for that matter, because the shares were issued to other people at over £1. Wouldn't be in breach of 580 because of that, because the company would have received the par value of the share. It could issue as a premium and leave the premium uncalled, but again, that's nothing to do with 580. Now, when then the friend started with the contract, because in his submission, one can only look at contractual consideration. I note, however, that that is not a phrase that appears in the relevant statutory provisions. What one is concerned with is subscription in money or money's worth. That is section 582 itself, that hopefully tab 4. Sorry, tab 6. Nope, tab 5. Tab 5 of the authorities bundle. What's required? 5821. Shares allotted by a company and any premium on them may be paid up in money or money's worth, including goodwill and know-how. That's the starting point. And 582 sub 2, this may be the provision that your Lordship had in mind for bonus issues. This section does not prevent a company from allotting shares to its members or from paying up with sums available for the purpose any amounts for the time being unpaid on any of its shares. So that is the basic rule for how the company must get in the amounts it's required to get in on the share issue. 583 to which my learned friend refers, is a provision to do with cases where payment is required to be made in cash. But this isn't part of a general rule. This is a definition which is used for certain obligations of public companies. What this obviously says, 5832, a share in a company is deemed paid up in cash or allotted for cash if the consideration received for the allotment or payment is a cash consideration. And cash consideration is defined as cash, cheque, release of a liability, and undertaking to pay cash, or payment by any other means giving rise to a present or future entitlement to payment, and so on. Now that's a specific definition for cases where cash payment is required. It's not the general rule for payment on share issues. And it's not a general prohibition on non-cash consideration. So if we continue with the case,
Just explain to me, how does this fit into the structure of the case?
oh well,
I thought your point essentially is that Mr. Stoneman and Mr. Ralph will pay cash as and when their liabilities are called. They'll hand over cash.
but my own friend's case that one has to look at contractual consideration, as I understood it, depended in part on this reference to cash consideration in 583.
I see.
All I'm saying is that cash consideration in 583, there are 2 points. First is that is not relevant to the general case. It's only relevant to certain situations relating to public companies, as we see in 584. The other is that in any event, it's not here talking about contractual consideration. It's talking about the form in which the amounts received in relation to the share issue are to be procured by the company. And my then friend's approach confuses, in my submission, the relationship between the statutory obligations of the company and the shareholder and any contractual obligations between the company and the allottee related to this. And this is section 33. The way it works, in my submission, is that on agreeing to become a shareholder, and by virtue of agreeing to become a shareholder, the relevant person becomes obliged, as a matter of statute, to make the relevant contribution to the company as and when called. That is elevated, if that's the word, to a quasi-statutory obligation by section 33. One wouldn't need to find, although one often would find, a contractual obligation to make that contribution because the statute imposes it. So it's not that the company law follows a contractual
where
obligation.
have you got section 33?
I think it went in at the very
Tab
start
5.
of the bundle.
Yeah.
It was the one I handed out.
Money payable by a member to a company under its constitution is a debt.
Well, it's both. It's 30. The provisions of a company's constitution bind the company and its members to the same extent as if there were covenants on the part of the company and of each member to observe those provisions. So that terminology, making it a covenant, makes it effectively a contract.
Covenant meaning what? Promise under seal?
No. It may have been originally, actually, because 33.2 originally made it a specialty debt, and that was relaxed in 2006 to make it a simple debt. But I had understood it to mean simply a contractual obligation.
Well, I put the question that way because Mr. Sykes seemed to accept that if things had been done by deed, there would have been good consideration.
Well, I think what my learned friend accepted is that if a debt had been created by deed and had then been released, because that debt created by deed would have been enforceable, the release would have been effectively a cash payment. I may have misunderstood that point, but I wasn't myself relying on debts created under seal, specialties, deeds, or anything of that nature I was simply relying on or taking the court to section 33 to show what I would say was the priority between the statutory obligations and the private law obligations. And there's the statutory obligations which come first and which are converted by section 33. It's not just, it's the Constitution as well, of course, but converted into contractual or quasi-contractual obligations by section 33. Generally by 33.1 and then 33.2 specifically in relation to monetary obligations, making them now simple debts, whereas previously they were specialties or quasi-specialties. We have a bit more on this in the skeleton at 20 to 25, but the essential point is that section 582, referring to money or money's worth, doesn't refer to any form of contractual consideration as such. Now, my learned friend referred to two extracts from the textbooks, which he said made it clear that nonetheless one was only talking about contractual consideration. The first is actually the last tab in volume 3 of the authorities, tab 48, volume 3. Now, if we start at the beginning of this section, as far as private companies are concerned, any valuable consideration prima facie suffices. For example, an agreement to render services as by becoming manager for 5 years. It is, however, obviously beyond the power of a limited company to release a shareholder from his obligation without payment in money or money's worth. You pay shares for nothing and preclude, this is a quotation from the authorities, and preclude itself from requiring payment of them in money or money's worth. That's the rule against discount. In the common law, or the general company law. Thus, as a general rule, an agreement to accept the supply of goods at a future time against calls is not valid. But that is to agree that future calls may be satisfied by damages for breach of a contract to supply the goods. There's an agreement by the company to pay a sum of money at once for future services, and to satisfy the amount by an issue of fully paid shares may contain good consideration for the issue of fully paid shares. Where the consideration is apparently valid at the time of allotment, but subsequently turns out to be worthless, the allotment is still good and the company will go back on it. So it's quite a generous provision in a sense, but that does show that one's looking at the time of the allotment. Now, it's against that background that one sees the sentences relied on by my learned friend. The company cannot, by a contract, make that which is not good consideration in law a valid payment for shares. Thus, past services for which the company is not liable to pay could not free the shareholder from liability, even under a contract to that effect. What that's saying is, one can't create value where there is none by using a contract. It is not saying that one can only have contractual consideration for the issue of the shares. And similarly, if we go to the extract from Palmer's at tab 45, page 911, it's just making the same point. It's making the point, if we read the whole paragraph, in relation to public company statutory intervention to guard against various abuses just mentioned, through overvaluation of non-cash consideration has been taken further. So that's the rule against non-cash consideration for public companies. Nevertheless, the law as developed by the courts in earlier cases is still of relevance, particularly in relation to private companies, although in relation to public companies the cases must now be read in regards to the statutory safeguards and so on. Thus, if a valid contract is made by the company as in consideration of specific property or of services of substantial value, the court will not examine whether the consideration is adequate as long as the contract stands. However, there must be some consideration, and so shares issued for a past consideration or by way of gift cannot be treated as paid up, and the others cannot be made liable to pay for them. Sorry, can be made liable to pay for them. Moreover, if the consideration is clearly not equivalent to the nominal value of the shares, or on the face of it is illusory or colourable, then the shares have to be treated as issued as a discount, and the shareholders may be held liable to pay for them in full. And what's that? That isn't saying one can only look at contractual consideration, or that consideration means contractual consideration. It's saying that the court won't look behind the contract unless it's an egregious case. That's my gloss, but that's the thrust of it. It can't be elevated to saying generally that there's a requirement for a contract, or that one can only look at contractual consideration. Now, obviously,
there has to be an exchange of some sort, doesn't there? Shares for something.
Yes. There has to be value got in for the issue of the shares. It's only whether one imports the full rigmarole of English contract law when ascertaining that, or whether one looks at the position more generally to see whether value has been got in return for the shares. Now, on my submission, none of this actually matters in the present case, because in my submission, the starting point is that the director shareholders are paid remuneration in the amount of say, 100. They are paid that on terms that they will subscribe for shares of 100, such shares to be paid up as to 1%, and obviously with the possibility of a call as to 99%. That is to put things in their full context, as the learned judge did, rather than to take a blinkered view, looking solely at the contract as respect my learned friend is asking the court to do. In the full context, one sees of remuneration, may or may not be taxable, that's for somewhere else, but the payment of remuneration on condition that shares are subscribed for, and those shares are subscribed at par, albeit only paid up as to 1%. Very simple. And what, of course, that means is that there's no question of a discount, because the only payment from the company is a payment of remuneration in substance. And that is how the flow of cash, credits to the director's loan accounts, is treated. And then that's the outflow, the flow from the company. On allotment, issue, and payment of the 1%, obviously funds flow back to the company. And as my learned friend said, what one sees in the accounts, therefore, is an expense, a remuneration expense of 100, using that figure, and then a credit to share capital of 1%, the 1% paid up, and a note that the 99% remains uncalled. Now, as you say, that is not a discount. It may be instructive just to see that in the accounts in a little more detail. So in the accounts, the relevant sections are set out in the judgment, paragraph 111, which is in the core bundle, tab 7, page 117. Now, my learned friend said that his clients didn't accept that the accounts were actually right, but there's no appeal against the finding in relation to the accounts. So for the purposes of today, what the judge says about the accounts must be taken as correct. So what we see summarised here start note 2, operating loss profit, and over the page, one element of that is directors' remuneration of 2.2 million odd, with a note underlined that included in the total directors' remuneration figure is an amount of 218,000 paid to directors in consideration for each director agreeing to subscribe for Class E shares. There's a footnote there, just to emphasise that something's gone wrong with the maths. 2180 divided by 2 is 1090,000, not 1080,000. And then the schedule of administrative expenses carries that error through, but we see the same figure. Director's employment expense, 2.18 million. So those are the entries in respect of remuneration. That is the basis on which the flow of funds from the company was justified and reported in accounts that were intended to give a true and fair view of the company's affairs, of course. It hit the P&L on that basis. And then we have, at note 11, the entries in respect to the share issue, which show quite properly in my submission, subject to the numerical error, the issue of the Class E shares called up as to 1 pence each, with the explanation that this was in consideration, etc., which is obviously the wording of the relevant agreement. Now, of those amounts, it says 1,080,000 was fully paid, and just under that amount was credited to a director's loan account. If we were to go back to the full facts, we'd see that there was a payment to Mrs. Stoneman and a credit to Mr. Ralph's loan account, but nothing turns on that. What we don't have, what we don't see in the note, but which one can deduce from this, is that the amount used to pay the call, i.e. 10,900 for each director, is included in that fully paid or loan account amount. So the overall effect of this...
Sorry, the amount used to pay the call is included where?
It's included in the 1080.
Right.
Sorry, no, it isn't. I'm sorry, it isn't. That isn't fully paid, it's on top of that. So one has to add that back in to get the fully paid amount. The distinction is between the 1p and the amounts fully paid.
Yeah.
As I said, the numbers don't quite work because there's been a slip and the division has just gone wrong, but the thrust of it is clear. So the overall effect of that is that 2.18 million is treated as an expense, reducing the profit for the year. But for this expense, there would have been distributable reserves, and for that matter, tax. 21,800 is added to the share capital, that's the amount called. And one can see from the note that these are £1 shares, and so one can work out that 99p remains to be called. On the face of the accounts, there's no question of a discount. And one can see that the payment to the directors has hit the P&L as an employment expense. That hasn't been taken from share capital or from the proceeds of a share issue. It's hit the P&L. And the share capital is properly credited with the amounts that have been called up. Those are the accounts found by the judge. Moreover, if you go over the page, this is now 115, page 120 in tab 7 of the core bundle. effect, the judge is saying that there's no ambiguity about that, no unreality about that. This wasn't a technical treatment. It seems to me, that no one could read these accounts, let alone sign them, without appreciating that the payments were being treated as at least related to directors' remuneration, and so on. That was the reality. It was the result that was needed in order to achieve the desired tax result. Now, I've lost track of the time, unfortunately. I don't think that clock is working, but no.
I make it 25 past,
So
so that clock is 20 minutes slow.
I'm grateful. Now, we've been through the points about consideration. My learned friend says that one can only look at the contractual consideration under the share allotment agreement, and that one has to look at the net effect of that agreement. This is repeating what I've said really, but just tying it into the judgment. First problem is that the payment to the directors is in substance remuneration. The justification for it is that it's remuneration. So the effect of the subscription agreement is not that the directors are issued shares for net consideration of nil, but the directors are paid remuneration on condition that they subscribe for partly paid up shares. That's in the judgment later on, paragraphs 188 to 189. And of course, my learned friend made the point himself that there are cases where there are two ways to carry out a transaction that are economically similar or even identical, but which have different consequences for 580, 552, and for that matter for tax purposes. We say that is actually a point against the appellant here, because what was done, as I've just said, is a payment of remuneration on condition of a share subscription, not a freestanding payment to subscribe for shares. So my learned friend's argument, we say, only gets off the ground by filleting the share subscription agreement, looking at parts of it in isolation, ignoring the context, the other documents, and the judge's wider findings of fact. It puts form over substance, despite the claim that it actually does the reverse. And the judge deals with that at 176 to 177. I don't need to turn this up. More than that, because I'm about to turn this up in effect, more than that, as the judge says, if the agreement were looked at in isolation, it wouldn't make any sense at all.
So where are you reading from now?
I was about to read from 178.
178.
Take the court
Thank
to
you.
178 in the judgment. Just the point that if one were to look at the agreement in isolation, this is 179 in fact, on the face of it, if the agreement is considered to be in substance a subscription agreement and nothing to do with remuneration, it's very uncommercial for both parties. And the logics can probably read on from there. It's very difficult for my learned friend to rely on taking the substance of something when his purported substance on the unappealed findings of fact made by the judge are very uncommercial. Indeed, at 180, if one were taking that in isolation, if that's all the agreements were about, i.e. the share subscription agreements were about, they would not sensibly have been entered into. One can't take them in isolation. It doesn't make any sense. In fact, we would go further and say that even if one were to take that narrow view, there is no discount. And that's because the shares are in fact paid up as to 1%. There may be a question as to where that money to pay up came from, but they are paid up as to 1%. And the 99% remains avowedly uncalled. The putative creditor inspecting the accounts can see that. The company has not foregone the 99 pence. The share capital account has not been inflated. No damage is done to the company's required maintenance of capital. What the creditor would see is that the share issue has been funded legitimately from the company's income account, not directly or indirectly from its capital account. And so the person inspecting the accounts, along with this agreement, would see that there's no discount. The most that could be said, perhaps, is that the 1% is a discount, though we wouldn't accept even that. Now, all of that is effectively and certainly consistent with what the judge says at 234, 240.
So one of the points you make is that it matters where the money comes from.
Well, it's more that the excuse for the payment matters, but yes, also where the money comes from, that it comes from, or it hits the P&L, it doesn't come from, it doesn't hit the share capital account.
Now, in the Hong Kong and China gas case, the judge didn't seem to have investigated where the money was going to come from to pay Mr. Glenn in the event that the company issued further shares. Is that something he should have done in your submission?
Well, maybe with hindsight, but what obviously happened there is that the agreements were looked at in isolation.
Well, what it was argued, this is all part of the original price for the concession.
Yes.
And the judge rejected that.
Yes.
Said no, it wasn't, because the company could increase its share capital at any time for any reason, nothing to do with this particular concession. But he didn't go on to ask himself, well, where was the money coming from?
Yes, or what alternative firies might there have been to justify a matching payment to allow the issue of the shares fully paid up. What I'm not sure about offhand is precisely what the Hong Kong statutory context was. Right. What the statutory context
was. Some point I'd like your help on that case.
We will do that. That's a we that is happening behind me very diligently. But what we have here is, we would say, a very long way from that. We do not have a freestanding agreement. We have an agreement that has to be seen in the context of the payment of remuneration, to which this has been appended in order to achieve a certain result.
Does it make any difference whether the services were or weren't past consideration? No. On your submission?
No, not directly. What makes a difference is whether or not the remuneration was validly awarded. But on the facts found, it was. Because the shares are not being issued in return for consideration consisting of past service. They're being issued in return for a payment of cash, which actually I think was your Lordship's point earlier. And the consideration is cash. The remuneration argument just explains how it is that the directors had the cash to fund their obligations under the agreement. That's maybe slightly overstating it, because obviously the share issue is conditional, but the main relevance of the remuneration and the service points is that it explains why they are being paid money in the first place, which they are then obliged to use as the 1% to pay the call on the shares that they're being issued with. Now, that subject to the greater detail on some of those technical points that's included in the skeleton is all I wanted to say on discount. On commission, again, this is set out in...
Well, it's no longer argued it was commission. It's argued it was discount.
Oh, sorry, I mean 552.
Yeah.
Yeah. I mean, the oddity from our point of view, of my learned friend's new argument, is that discount in 552 effectively means commission, and that's what that's clear on the authorities. So it's not really about terminology. That's and to make that point good, it's Licensed Victuallers Mutual Trading Association, which is, or ex parte ordin, tab 13, First Authorities Bible. It's worth reading the head note. Context is important. This is obviously an issue of the discount case, but the point is the words are not wholly distinct in terms of art. But in fact, I think my learned friend and I are agreed on the substantive point in relation to 552, that the real difference is, in relation to discount, is what amount should have been collected, what is a discount from or a commission on. In the case of 552, it's the amount that would otherwise, or might otherwise have been collected, whereas in 580 it was the par value. So here, where we're talking about the issue of shares at par, and there's no suggestion that anyone was going to issue these shares at anything other than par, so there's no material difference. In terms of whether or not there was a commission stroke discount, there is a difference in that there's an additional hurdle in 552, in that the prohibition is on the application of shares or capital money to pay commission. And here we would say my own friend simply hasn't got the findings that he would need to show that shares or capital money had been used. On the contrary, what one sees is that the payments have hit the P&L, they've been justified in terms of remuneration. So it's a long way away, we would say, from the payments of commission in application of shares or capital money. So
Do you agree with Mr. Sykes that the money came out of trading income?
Yes. I mean, certainly for the first payment, there was the large DHL contract. So for that year, if nothing had been done, the company was going to show a very large surplus on its trading account, which was good news, but the bad news was that they'd have to pay tax on it.
Yeah.
So it had to hit the P&L, it had to be an allowable expense for tax purposes in order to achieve its aim. So yes, absolutely, it had to come out of trading receipts in effect. Well, sorry, it had to come out of the company's income in effect. So those are the two main points on 552. First, there is no, now agreed to be no commission, but we would say neither is there any discount. And secondly, even if there were, it wouldn't be one that's out of shares or capital money. It's out of the P&L. And again, I mean, there's no real dispute. These are the points that we've flagged in the skeleton. There's no real dispute that we're talking here about form and not substance. In our submission, clearly that is something, given the findings, that helps the revenue rather than the taxpayer. And I think that is probably all I need to say on 552. We will come back on that one. We haven't. Yes. So I know in Junior's notes, if we go to 539 of the judgment, which is 307 of Bundle 2.
Sorry, where are we going?
Sorry, if we're going to the Australia, the Hong Kong and Glen case.
Right. This is authorities.
Authorities 2. Sorry. Sorry, tab 22, which is actually the last one in tab in volume 1. Sorry.
Right. Authorities 1.
Yes, I
Tab
apologise.
22. Yeah.
Authorities 122. And if we pick that up at 307 of the bundle reference, which is 539 of the judgment.
Yes.
What we're talking about, the argument was, at the top, this is the real pinch of the case, the transfer of the concession, though made once and for all in 1862, was a sufficient equivalent in kind, not only for the discharge of the liability on the first 400 shares to be issued at the concessionaire, but also for the discharge of the liability on the fifth of any increased capital that might at any future time be issued to the concessionaire by the company, which I think is probably the passage that your Lordship had in mind, that the original consideration was going to justify all the...
Yes, well that's what the Mr. Glenn's executors argued.
Yeah.
The judge then rejects that, and he comes to looking at it, looking at the contract at page 309, bundle page.
Yeah.
No, sorry.
Well,
I beg your pardon. No, it's 308. He says.
Yeah. Yes, I think it's the top of this page, isn't it?
Yeah, fifth of future increases has no connection with the value of the concession,
yeah,
etc., etc. But what the point I was putting to you, what he doesn't do is to ask himself where the £5,000 is going to come from.
Oh no, sorry, no.
Because one of the points you've been making is that the money paid to Ms. Stoneman and Mr. Ralph didn't come out of the company's capital account, it came out of trading income. But that doesn't seem to be a question that Mr. Justice Sargent asked.
Well,
where the money was going to come from to enable Mr. Glenn to buy the shares. Now, it may be that there is some clue in the way that Mr. Younger framed his argument, because what he said, find it. Yes, bundle page 300, just before the end of the last main paragraph on the page. He says the net result of the two operations, out of every issue of £20,000 new capital, the company gets only £16,000, while the vendor gets £4,000 in fully paid shares without paying or giving any consideration for it. So that was the company's complaint.
Yes.
Which does look as though it's talking about the capital account.
Well, I think what's happening there, the vendor is paying something for the shares. He's paying the £16,000 out of the 20, but that's being treated as if he had paid 20, and that's the effect of the agreement. The complaint is just above that. The complaint is that under Article 8, on every increase of capital beyond the fixed amount, a fifth of the new shares are to be allotted.
Yeah. So he's saying a little further up, he says there should be 400 shares of £10 each. These to be allotted to the vendor, and contemporaneously £4,000 is to be placed in the hands of a nominee and a nominee of the vendor, who are immediately to apply the 4,000 and paying up in full 400 shares. We are not complaining of that. So the complaint doesn't seem to be about circularity of money.
No, that's true. Not in relation to that amount. No, it's the failure to get in the additional amounts.
Yeah.
Yes. Well, I'm grateful for that more detailed analysis. But again, clearly the fundamental point from the revenue's point of view is that is wholly different from the situation in the present case.
Yes.
Unless I can be of further assistance, those are our company law submissions.
Yes, Mr. Sykes.
Thank you, my lord. I'll try and be brief, but there are some important points that I need to deal with in relation to what my learned friend said. Just before I begin, the case that I refer to that says that the articles are simply provide the vary, the articles, the regulations, the articles of a company simply provide the viries for further agreements, including the viries for subsequent remuneration. They don't actually award remuneration themselves. Is a case called Hickman, which I'm afraid I don't have, but I'll try and get that during lunch. It's 1915-1 CH 881. And I haven't been able to find yet a criminal sanction for breach of Section 552. There is a case called Zinc Mines, which says that the money has to be paid back.
Link lines.
Zinc Mines.
Zinc mines.
And again, I'll bring that during lunch.
Yeah.
Now, the first fundamental point is that the contract that has been described just now is not the contract that we're talking about in this case. I mean, what my learned friend said is that the payment was made as remuneration on condition that it be subscribed for shares. That's not the contract at all. The contract is at core bundle tab 12, and it's very clear, page 192, the core bundle. in consideration of the C1, in consideration of the employee offering to subscribe for Class E shares, substantially in the form of offer, the employer shall pay to the employee a sum of 10,900 followed by 1,079. So the consideration for the 1.1 million is solely the offer to subscribe. Services are neither here nor there in this. Of course, they provide the background to this, because the effect is that effectively the employee has got the benefit of funds for a finite period until there is a call. And that is, in effect, an interest-free loan to the employee. And why is that benefit being conferred? Well, that's the reward for services, the arrangements as a whole, but the actual payment itself is for, that's not consideration, that's the motivation. The payment itself is for subscribing.
What do you say about recital B?
That's simply the background, and what I say to that is that is the background. It's a reward to the employee to enter into these arrangements, allow the employee to enter into these arrangements, because what's happening is the company's saying, in substance, you can have these funds, and then you'll have to pay them back to me, but you don't have to pay me interest in the interim, and that's the reward. It's not, here's 1.1 million, that's your reward, because if that was my reward, I certainly wouldn't then go on to subscribe for these worthless shares when I have to pay it back. So clearly, it's the arrangement as a whole that's the reward, not the payment. And it's non-contractual in the sense that it's the motivation behind the arrangements, but the services aren't any part of the actual consideration. Now, the suggestion that the debate in the High Court was whether this payment was remuneration or a distribution, and it was gratuitous either way. The significance of that distinction was that if it was a distribution, the debitor reserves needed to be absorbed by distributable profit. If, on the other hand, it was remuneration, then you didn't need distributable reserves to permit that payment. So the points that my learned friend has taken you to in the judgment are all dealing with that distinction. One gratuitous transaction, gratuitous transaction analysed in one way as opposed to another way. Because in order to be remuneration, it doesn't need to be contractually due for services. In my supplementary skeleton, I referred you to Re-Halt, and where it's accepted and common ground that although frequently payments made to directors are gratuitous in the contractual sense, they're made after the event, the consideration is past. Nevertheless, the judge says, well, that's still the exercise of the valid exercise of the power to award remuneration. And that was the debate in the High Court on distribution. So saying that this arrangement was remuneration, or the payments were made as part of the remuneration, doesn't answer the point, the contractual point, which is relevant to section 580. And the revenue say that we haven't appealed that particular issue. Well, if I could,
your ground 5, I think.
Well, indeed. Now it's ambiguous because these are sort of ambiguous terms. Remuneration, does it mean contractual consideration for services, or does it mean a reward for services? It's being used in those two ways. In either of those ways, when it comes to the distribution argument, but when it comes to the discount analysis, what's absolutely key is what is the contractual position. So those statements that it's remuneration don't answer in any way, shape or form the analysis on discount. And as I say, it made sense as an employment reward, ex gratia, but it doesn't change the fact that the consideration for the money was the offer to subscribe, which brings in discount. In terms of the submission that company law doesn't require contractual consideration for the issue of shares, I find that, frankly, quite an astonishing submission. It's perfectly obvious in my submission that for a company to issue shares, it must receive contractual consideration. Indeed, even the judge appears to have considered that, to have accepted that, although not very clearly. Find the right section. Page 147, paragraph 235. The bottom of paragraph 235, he says, the payment for the shares is therefore, he's talking about shares in general, the payment for the shares is therefore the contractual consideration provided to the company. Now so the judge accepted ultimately that we are looking at contractual consideration, and there's no respondent's notice to restate or to bring that argument, the revenue, back to life. Now, the kind of consideration that one needs when one is dealing with services, because you're taken to provisions of the Companies Act, well, one gets an idea of the kind of thing that is needed from section 591, as far as services are concerned, which...
We got that in our bundle?
Yes, you have. You had that before as well. It's not an addition. Tab 5.
591, did you say?
591.
Yeah.
It's instructive. Enforceability of undertakings to do work. An undertaking given by any person in or in connection with payment for shares in a company to do work or perform services or to do any other thing, if it's enforceable by the company apart from this chapter, is so enforceable notwithstanding that there's been a contravention in relation to the provision of this chapter, or chapter 6. That's the kind of consideration in relation to services that would be required, an actual undertaking to perform services. And as regards past services, one would need a crystallized debt obligation to pay for those. And the only way to do that, unless there is an employment contract under which that person is entitled to a specific amount of payment for their services, is to declare a bonus and then enter into a deed in order to make that a valid obligation. That wasn't done, and it wasn't done because the whole point of this was that the remuneration was not the payment, but it was the benefits as a whole. Otherwise, why would you take your 1 million and then put it back into the company for worthless shares? So, in my submission, the point that consideration is required is absolutely clear. The agreement, reading it, it's perfectly plain. The consideration for the 1 million, for the 100, is nothing to do with services. It's the agreement to put the money back into the company to subscribe for these shares. And that's all there is to it. The services is merely the background as to why these arrangements were entered into. So my submission is perfectly clear that this breaches the rules on discount if one accepts, as the judge didn't, but if one accepts that offsetting payments where there's no other service beyond the subscription are taken into account. And finally, on section 552, I'd make the point that one is dealing with the language there directly or indirectly, and that makes it very broad, far broader than HMRC suggest. So unless I can assist judgeships further, those are my final submissions.
Well, thank you, Mr. Sykes. So you've got a little bit of homework to do.
Yes, may I just check?
Yeah.
So the sanction for 552, the Hickman case.
You were talking about zinc mines?
Zinc mines.
Well, Lord, if I may, since it was said that a point I made should have required the respondent's notice, maybe just for the note, but 234 to 235 in the judgments below at 147 of the bundle read, if you read the whole of those sections, one can see that what the judge is saying is, I do not think that consideration is being used in its strict contractual sense.
Yeah.
Rather, it's concerned with the form of payment for shares and ensuring that full value is received. But that's my submission. It may be that there was consideration, but in terms of the actual law, the judge was with the revenue at this point.
Right. 2 o'clock.